As you know, RCAF is on the leading edge of many, many issues. One of the most significant is the lawsuit that we filed in April of 2019, alleging that the four largest meat packers have unlawfully conspired to depress cattle prices paid to producers and to inflate prices paid to consumers. And that litigation is ongoing, and it's grown considerably. And it's my pleasure to welcome one of the attorneys working for you in that national antitrust class action lawsuit. His name is Daniel Herrera, and he's an attorney with Cafferty, Clobes, and Meriwether and Sprengel, and he's going to give you an update. Daniel represents clients in federal and state cases nationwide, ranging from antitrust and commodity class actions to shareholder derivatives actions and product liability, privacy, and data breach suits. Mr. Herrera has played a key role in developing the firm's successful consumer fraud practice. Mr. Herrera has been actively involved in a number of the firm's successful actions, including the Anderson versus Bayer Processors Corporation class action lawsuit and several others. He's received his law degree, magna cum laude, and his MBA with a concentration in finance from the University of Illinois. He hails from Chicago, Illinois, and I'm going to welcome him to the podium right away. Please welcome your attorney representing you in the most significant litigation perhaps the cattle industry's ever been involved in. Thank you. Daniel.
Thank you very much, sir. Appreciate it. Good afternoon, RCAF. I'm Daniel Herrera, as Bill just mentioned. I'm a partner at the law firm of Cafferty, Clobes, Meriwether, and Sprengel. We're one of the firms serving as co-lead counsel in the cattle antitrust litigation. I am sure, as is often the case, you're all thrilled to sit here and listen to a lawyer drone on. But I'd like you all to look on the bright side. They only gave me 30 minutes, and at the end of this talk, none of you are going to get a bill in the mail. So things are looking up. Kidding aside, before I begin our annual litigation update, on behalf of myself, my law firm, our co-lead counsel at Scott & Scott and Robbins Kaplan, and the literally hundreds of attorneys who are working on this case, I'd like to thank not only RCAF and the board, but also you, its members, for the opportunity to represent you all in this groundbreaking litigation. I know my bio probably doesn't suggest it, and I certainly don't look it. I'm a first-generation Cuban-American with a thick Chicago accent. But my family actually has a history in agriculture. My great-grandfather toiled and saved throughout his youth to eventually purchase a citrus grove, which he owned and operated for over 3 decades. Given where he lived, I'm sure you can all guess how this story plays out, so I won't bore you with the details. But that's just to say that we understand and appreciate all the work and effort you all put in to keeping this wonderful country fed and running, and we're incredibly honored and could not be more grateful for the opportunity to represent you in this case. I hope I'm going to get this button right here. I think they said it's the green one, big one. So starting first with a litigation update. This case kept us very busy last year. For those of you who were in attendance at the convention in 2022, you heard from my colleague, Pat McGann. We spent the better part of early 22 negotiating a case schedule, negotiating the types of documents, data, and other information the defendants were going to give us in this case, and exactly how they were going to go about locating it. And those efforts continued on into the fall and spring, and eventually culminated with considerable motion practice before our court, which is the federal court for the District of Minnesota. I'm proud to say that for the most part, our efforts were successful in attempting to get us what we need. Certainly couldn't have done it on our own. As a tag along to this litigation, which RCAF was so instrumental in getting off the ground, various classes of beef purchasers have now also filed lawsuits. Their attorneys are helping with this litigation as well. And when I tell you that it's truly hundreds of attorneys, it really is, because it takes an army to litigate a case of this size and importance. With those efforts out of the way, we've now moved into heavy discovery. The defendants in the case have produced over 6 million pages of documents, emails, text messages, terabytes of data that our economic experts are poring over. We've also subpoenaed documents and data from a slew of third parties, such as non-defendant meat packers, defendants as employees, industry participants, who I'm sure many of you are familiar with, and even the USDA itself. Defendants have done the same. They're subpoenaing data and documents from cattlemen's associations, some of whom we're representing in connection with those subpoena negotiations. So the next deadline you see on the screen in front of you, that's what's called the substantial completion deadline. I know that sounds like fuzzy legalese, and that's because it is, as most legalese tends to be. By next week, defendants are supposed to produce to us the vast majority of the documents that they intend to produce in the course of the case. We're also still working through some discovery disputes that will likely require us to appear before the court in short order, but we're now about ready to move into the next phase of the case, and that's depositions, deposing the defendants as employees, and we expect those efforts to begin in the coming weeks and months and likely carry over into the early part of next year. And that's going to lead us into our next major deadline, and it's really the big one for any class action case, but particularly for antitrust litigation, and that's our deadline for our filing of our motion for class certification. And that's when we ask the court to decide whether it can hear in a single trial the claims of every individual who was similarly harmed by the unlawful conduct that we allege. And in this case, that class consists of every rancher who sold fed cattle to one of the defendants, and I won't belabor their names, it's the big four you all have heard about so much today, anytime between 2015 and 2020 on anything other than a cost-plus basis, or transacted in CME live cattle futures during that same time period. That motion is going to be fully briefed by early September, with the hearing likely to follow shortly thereafter. And I don't think I can understate how important succeeding a class cert is for a case. Failure to do so can really be the death knell for it. So I assure you all we have our eyes on the prize, and we're working to get our ducks in a row before that deadline hits. During that window, we're going to be working on other key tasks as well, primarily assisting and defending the work of the countless economists and other experts that we've retained to assist us in the litigation, not just for class certification, but also for the liability phase of the case. And that's when we do our darndest to make sure that we secure the relief to which we believe you guys and other class members are entitled. Now, looking a little further out from that, and you won't see any deadlines up there, if we succeed at class certification, which we fully expect to do, it's usually always followed by an appeal. The appeal does not need to be heard one way or the other once that appeal is resolved, either because the court refuses to hear it. In this case, it would be the 8th Circuit Court. It's a federal appellate court that oversees the District of Minnesota. Once it's resolved, we go back to court and we enter the liability phase of the case. That's almost always accompanied by a motion for summary judgment. That's when the defendants tell the court, these guys don't have enough evidence to sustain their claim, so you should kick them now anyways. But if we're successful in defeating those efforts, that's when we'll move into trial. And frankly, at this stage, at the earliest I could imagine that would happen would be sometime late in 2025. So it goes without saying, and I know you guys hear those dates, and it sounds like a long time, and the wheels of justice do grind slowly, as people like to say, but it's not going to be for a lack of effort on our part. We're going to have our hands full over the next 2 years, but we fully intend to continue to zealously advocate, not just on behalf of our CAF, but also on behalf of its members like you and ranchers across the country, and that's exactly what we intend to do. So the slide's entitled, Join in the Class, and it's probably a bit misleading. Probably saw an identical slide last year. We always like to really stress this point to give everyone comfort, because we often hear from class members, what do I need to do to join the class? And the answer is absolutely nothing. You're either a member of the class or you're not. And given, as we heard today from Coy earlier, that the big four packers purchase about 87% of the fed cattle sold in this country, I'd venture to guess that most of you fit our class definition. So there's no need to do anything specific at this time. You don't need to hire an individual lawyer. It would defeat the purpose of a class action if you were forced to, because the idea is that by proceeding as a class, it eliminates the need for people to file their own individual lawsuits, which Believe me when I say it can be very time and cost intensive. You will have additional rights, even in the event that a class is certified. Folks are always allowed to opt out, which means to sever your claims and proceed on your own, if you so desire. And if a settlement's reached, you'll also have an opportunity to object to the settlement's terms if you think they're unfair. But I'd be shocked if the board here at RCAF ever allowed us to suggest entering into a settlement agreement that they felt would be unfair to its members. And lastly, and it's the last point up on the screen, and it's a really important one, in the event that a settlement is ever reached or that we secure a verdict in favor of cattle ranchers, you are going to need to be able to present documentation to support the amount of loss, the amount of damages that you claim you're entitled to under the settlement agreement or as a result of the verdict. So that means to please do your best, retain any paperwork associated with your sales of fed cattle during the 2015 to 20 period. Make sure to maintain any records of any CME futures that you purchased for hedging purposes. Losing that documentation could ultimately impede your ability to participate in any recovery we're able to secure for you guys. So I can't stress it enough. Make sure to keep all that paperwork hidden away and secure, and make sure it's available in the event that this case moves to a successful conclusion. So on the government front, there's not as much to report here as there have been in the last couple of years. It's now been confirmed, as many of you probably know from the news, that the Department of Justice has been investigating the Big Four packers for potential price fixing and other anti-competitive violations. The USDA and various states' attorneys general are engaged in similar investigations. Unfortunately, there's not much known about what those investigations entail or where they're going, at least at this time, but we will be absolutely certain to keep the RCAF board apprised of any developments that we learn of. Also, based on recent reports from earlier this year, a bipartisan group of senators has again proposed that Congress pass the Meatpacking Special Investigator Act, and that would create a group within the USDA's Packers and Stockyards Division that would be specifically tasked with investigating potential unlawful anti-competitive conduct by large poultry and meat processors. We spent a good portion of this morning talking about the Packers and Stockyards Act. It's an ancient piece of legislation. It's since, frankly, underutilized. You don't see much litigation using it. We're now starting to see a more active USDA try to prosecute collusive behavior under the Packers and Stockyards Act. But as is true of a lot of government agencies, ultimately they need the resources in terms of the manpower to be able to commit the time and effort required to complete those investigations. So if we'd like to see more enforcement under the PSA, I'd encourage you to reach out to your senators and congressmen and urge them to support that bill. And my last update involves other litigation in other protein industries. Pardon, let's see if we can get this fixed. Oh, well, I must have forgotten one. I'd like to preface this with a word of caution. It's important not to draw conclusions about how the cattle case is going to play out simply because of what's happened in other cases. Allegations always differ, market structures differ, the facts on the ground differ. But that doesn't mean that they can't provide a useful roadmap, not only for a potential successful outcome in this case, but also what we as the attorneys will need to do, the evidence we're going to need to marshal in order to ensure that this case is successful as well. The broiler chicken litigation pending in federal court for the District of Illinois in Chicago is the furthest along. There, the court recently dismissed several of the defendants at summary judgment for a lack of evidence, but sustained the claims against about 8 others. That case is moving to trial in September for those defendants who are still in the game. And that's, of course, without mentioning the fact that the plaintiffs there have secured hundreds of millions of dollars worth of settlements for chicken purchasers across the country from defendants who have settled their way out of the case. There's also a turkey price fixing case pending there. Many of the same defendants as here again, Cargill, Tyson, JBS, they're all involved there too. Motions to dismiss were denied last year, and it's now moving into the discovery phase. And last but not least, there's pork, and this is probably the most interesting for our purposes. That case is pending in the District of Minnesota as well, and it's pending in front of the two very same judges who are overseeing the cattle case. Earlier this year, they granted class certification. The defendants appealed that ruling to the Eighth Circuit Court of Appeals, and the Eighth Circuit declined to hear it, which means they're now moving into the liability phase of their case as well. There have also been considerable settlements reached in that case, but for present purposes, what we're most interested in is how that case continues to play out over the coming months, because it will very likely give us incredible insight into what we need to do to succeed before those very same courts. So we will keep our eyes on that one for sure. And with that, I really appreciate you all giving me 10 or 15 minutes of your time. I tried to be as brief as possible and as informative as I could, and I'm happy to answer any questions y'all might have that I'm actually able to answer here in a room of this size.
You said it was important. You said it was important to keep track of sales receipts because we fed cattle like forever. And going back to 2015, do I just keep closeouts on that? What do I need to keep?
What I would suggest for the time being is that whatever you have, you hold on to it. Even if it means putting it in a plastic box where you're going to make certain that no water or moisture is going to penetrate it. You tuck that away.
That's where it's at.
You tuck it away in a safe space and you hold on to it, because nothing would be more unfortunate than managing to succeed in this case, knowing the relief that it's going to be, that it would make available were we successful to folks like y'all that are in the room today, only to have you be unable to participate because that paperwork's not available.
Okay, the next question is, you said to keep track of hedging since then, and Bruce does that, but he does it through our feeder. So I don't have any record of that because it goes through him. How would I retrieve that?
I want to be very careful here, because we tend not to suggest to anyone that they go out of their way to try to acquire materials, documents, information that are in someone else's possession or custody. What I simply do is review your records, see the extent to which there's any evidence in that paperwork of your transactions in CME live cattle futures. Worst case, if you want to give yourself some comfort, you could contract your feed yard, but without knowing the specifics, I can't tell you for certain whether ultimately you'd need something more than what you have or whether what you have would suffice.
Okay.
But nothing's ever wrong with being proactive and making sure that you're well set up for the future.
Okay, thank you.
No problem, ma'am.
How and why did this case end up in Minnesota?
So part of that I can't answer. It concerns legal strategy. As I mentioned, as much as I'd love to discuss with everybody here any details they'd like to know about the case, obviously in a public forum we want to be very careful about what I say, and there are some things we really can only discuss with actual clients and in a confidential environment. My understanding, however, is that once some of these other cases got off the ground, and with particular defendants being headquartered there in Minneapolis as well, it seemed to be a reasonable location for the case to move forward. It was originally filed in federal court in the Northern District of Illinois, so in Chicago, which would have reduced travel for me at the present time. But ultimately, for a variety of reasons, the cases were refiled in Minnesota and were all consolidated there, and they seem to be progressing expeditiously.
Daniel, can you describe the different entities that have joined in some fashion, have joined into this litigation throughout the supply chain? We filed first for the fat cattle. We've got the direct purchasers, retailers. Can you discuss that a little bit?
Absolutely. As is often the case in antitrust cases, and this one's just a bit different because for the most part, in American civil actions, price fixing cases tend to focus on the purchaser side of things. Defendants collude and conspire to maintain artificial or inflated prices for the products they sell to consumers. Typically, you see two classes of purchasers. You have your direct purchasers, so those entities like wholesalers or large grocery store chains who would purchase boxed beef or case-ready beef directly from Cargill and the other defendants, as well as the consumers like us who end up purchasing it from those same retailers. Oftentimes, you have what I'd call other middlemen, commercial indirects, who purchase from a wholesaler and then resell that along to somebody else. This case has been a bit more complex because we're here representing you guys on the supply side, which is quite unusual for a price fixing case. But as is probably evident from the allegations, this is an atypical price fixing case because the real misconduct is alleged to have happened on the cattle side of the industry, on the input side. They're alleged to have suppressed the rate at which they slaughter fed cattle, to have coordinated in the way in which they purchase fed cattle from ranchers, and that in turn is what has led to higher cattle prices and higher beef prices, with some caveats, of course. I'm not as familiar with the specific litigations and the purchaser complaints. I know there are some that are particular to coordinated price fixing efforts for beef prices generally, but frankly, it's a huge help. The co-counsel in this case, if we took just the law firms working on the cattle side of the case, you'd be talking about maybe a couple of 100 attorneys available to work on this case max. Because these direct purchaser and indirect purchaser classes have come in, it's hundreds of additional bodies, and we really appreciate all the collaborative effort everyone's put into work in this case, because we couldn't do it without the attorneys for those other classes. That's how big of a case this one is.
You said that they have the same defendants, pretty much throughout all these lawsuits. Does that set a precedent in front of the court when you got the same big four packers getting drug in every time?
I mean, one's difficult to answer. All I'd say is we all have common sense, right? And oftentimes where there's smoke, there tends to be fire, at least more often than not. I can hear you anyways, Bill. You can have at it. Well, fortunately, I've been out of law school for 15 years now, so I no longer have to do it myself. There's just an army of attorneys under the age of 27 who are, and when I say tirelessly, I'm not kidding. When we wake up in the morning, there's more often than not a slew of memos in our inboxes summarizing what's been done, what's been looked at, how it fits together. It's just effort. It's really trying to put eyes on every single piece of paper that you come across, trying to inventory it in a way that makes sense. And then now we're really into the actual meat, no pun intended, sadly, of trying to wade through that morass of information and fit those puzzle pieces together so that we can move this case not just to class certification, but through summary judgment and on to trial if necessary. Cold bench, I'm happy. That works great. Thank you very much for your time, everybody. Again, we sincerely appreciate the opportunity to represent you all, and we hope we're able to deliver success in the near future. And thank you.